The Supreme Court in Bostock v. Clayton County, 2020, ruled that discrimination against an employee for being transgender or for not conforming to traditional gender expectations constitutes sex discrimination under the Civil Rights Act of 1964. This means that LGBTQ employees are protected from discrimination in hiring, firing, promotion, job assignments, and any other terms or conditions of employment due to their sexual orientation, transgender status, or gender identity. The Equal Employment Opportunity Commission, EEOC, plays a critical role in enforcing protections against the discrimination of LGBTQ employees. This course details the rights granted to LGBTQ employees by federal law and guidance from the EEOC. Gender expression is a person's gender-related appearance or behavior. Gender expression may be stereotypically male or female, a combination of both, or may not conform to any gender. Gender identity is a person's internal understanding of their gender, which may be male, female, a combination of male and female, neither male nor female, a gender different from the person's sex assigned at birth, or transgender. Transgender refers to persons whose gender identity differs from their sex assigned at birth. A transgender person may or may not have a gender expression that is different from the social expectations of the sex they were assigned at birth. Transitioning is the process in which an individual begins living as the gender by which they identify. The law protects employees who are transitioning, have transitioned, or are perceived to be transitioning to a gender other than the one assigned at birth. Sexual orientation can be heterosexual, attraction to the opposite gender, homosexual, attraction to the same gender, bisexual, attraction to both genders, or asexual, little or no sexual attraction to others. Queer is an umbrella term that encompasses a wide range of sexual orientations, gender identities, and expressions that fall outside traditional norms associated with heterosexuality and cisgender identities. The following supervisor conduct is illegal under federal law. Engaging in harassment or discrimination affecting tangible employment actions such as hiring, firing, demotion, or promotion. For example, refusing to promote a woman for no other reason than the fact that she does not dress stereotypically female, or terminating the employment of a worker who is undergoing or planning sex reassignment surgery. Requiring employees to tolerate harassment as a condition of employment. For example, a warehouse manager telling his employees that they will simply have to ignore homophobic slurs from their coworkers because they are commonplace in blue-collar jobs. Harassing or discriminating against employees because of a perception which is not true. For instance, a manager choosing not to give a job assignment to a woman because he thought she was a lesbian. Her sexual orientation is irrelevant in this scenario. She is protected either way. Making employment decisions or comments based on sex stereotypes. For example, refusing to hire job candidates whose gender identity is female for a job that requires heavy lifting solely because of gender stereotypes. Segregating employees based on actual or perceived customer preferences. For example, assigning transgender employees to non-public facing positions or transferring transgender employees to certain stores or geographic areas. Hostile environment harassment occurs when the conduct unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. Supervisors have the dual responsibility of avoiding harassing behavior themselves while watching for it in the employees they manage. The harasser and victim can be coworkers, but harassment can also occur between employees and non-employees, such as contractors, consultants, delivery persons, vendors, or even customers. Harassment can occur anywhere that employees represent their organizations, such as work celebrations, dining with clients, conferences, trade shows, sales calls, and charity events. Harassment can occur in person, on the phone, through text messages, instant messages, emails, or through social networking sites. Hostile environment harassment can affect anyone in the workplace. Even employees who were not directly harassed but were bystanders to illegal conduct could be victims. using demeaning or offensive names, or the use of slurs or epithets, telling insensitive jokes that are demeaning or degrading, using a customer's gender preference as a factor when assigning job duties to employees, making derogatory comments about the traits or legal rights of a protected group, such as, a man should not be wearing a dress, excluding or isolating coworkers from work-related activities and assignments. For example, assigning a transgender person exclusively to job assignments that do not involve customer interaction, when coworkers in the same position work with customers on a regular basis. Viewing offensive websites or using social networking sites to harass coworkers. For instance, making disparaging comments about gender expression on a coworker's social media pages, or viewing anti-gay websites in full view of coworkers. The EEOC mandates that all employees, including transgender and non-binary individuals, have the right to use restrooms and other gender-specific facilities that correspond with their gender identity rather than their sex assigned at birth. Employers may choose to have unisex or single-use bathrooms, locker rooms, and showers in lieu of gender-specific facilities. Denying access to facilities that align with a person's gender identity or requiring employees to use facilities that do not reflect their identity violates federal law. Employers must allow employees to groom and dress according to their gender identity. If an employer assigns gender-specific uniforms, employees must be allowed to wear the uniform corresponding to their gender identity. When employers have dress codes or grooming standards, transgender or gender nonconforming employees must not be held to different standards than other employees. Under federal law, employees have the right to be identified by the name of their choice and with pronouns that reflect their gender identity. Employers must ensure that all employees follow this pronoun and name preference or face liability in court. Misgendering, using incorrect pronouns or names not aligned with an individual's gender identity, is considered illegal harassment and subject to disciplinary action. Accidental misuse of an employee's name or pronouns does not violate the law. However, intentionally and repeatedly using the wrong name and pronouns to refer to an employee could contribute to an unlawful hostile work environment. Employers may use legal names and genders on government documents when obligated by law. All employees should be granted equal rights to access activities, benefits, and protections based on their self-identified gender, without unnecessary obstacles or barriers. Employees must be allowed to participate on work sports teams, team-building exercises, and volunteering opportunities that correspond to their gender identity. The EEOC advises that employers should provide health care benefits to LGBTQ employees that cover gender-affirming health care. Denying coverage for necessary medical procedures or treatments based on an individual's gender identity may lead to discrimination claims. Employers should provide reasonable accommodations for transgender employees during their transition. This includes allowing time off for medical procedures related to gender transition and ensuring access to facilities that correspond with the employee's gender identity. The FMLA allows eligible employees to take unpaid leave for medical and family reasons. Following the Supreme Court's ruling in Obergefell v. Hodges 2015, which legalized same-sex marriage, same-sex couples are entitled to the same leave benefits as opposite-sex couples. This means that LGBTQ employees can take FMLA leave to care for a same-sex spouse without facing discriminatory practices. Employees should not be asked for proof or documentation of their gender identity or any medical records related to transitioning. This means that an employee who wishes to be recognized according to their affirmed gender cannot be subjected to verification processes that infringe on their privacy or personal experiences. Retaliating against a coworker for filing a harassment complaint is illegal under federal law. Examples of retaliation include layoffs, negative performance reviews, job transfer, loss in pay, benefits, or overtime, less desirable job assignments, bullying, demotions, and unwarranted discipline, to name just a few. Employers and their supervisors must take reasonable steps to prevent harassment from occurring. Supervisors who fail to prevent harassment or who engage in harassment themselves can be found personally liable in court for large monetary judgments and face disciplinary action up to and including termination. Employees who engage in harassment or discrimination of LGBTQ employees could face disciplinary actions, including demotion, suspension, or termination. Harassment and discrimination based on gender identity, gender expression, transitioning, or sexual orientation are strictly prohibited. It's critical that all employees understand what constitutes harassment and discrimination and ensure that the employees they manage understand as well.